fire marshal, like in Richland County or in,
No, he's on Caleb McBride, I think his name is. He's kind of like the housing official over there.
is that in Lexington or Richland?
Richland County.
Okay.
Lexington County is kind of different. They're all handled by the sheriff's office.
Yeah, they got, I think that's the fire marshal or the fire department.
Yeah.
So it looks like we're getting more folks. We got about 7 minutes till they actually kick it.
And I like it. And whenever I do have to speak, he is like, that's so. Very what? It's not
Thanks, sir?
Sure. I got yours. I
Yeah.
keep it, trust me. I keep yours on my desk
Yeah.
all the time. I just have to refer them over to us. Call or go online.
Usually, what's the most common thing you help people with, like just the eviction process?
Well,
or
we
the-
go
or
through,
anything.
well, for example, I work with some of the veterans appeals, with the DA. I work with the kids who were expelled, disciplined in school. I work with people with Social Security benefits if they're denied, like they have to be denied for SSI or whatever they're being denied for. And then I also do some side stuff that, you know, might be like a name change in the family court, like they screwed up on birth certificate. So I got to petition the family court to fix this kid's birth certificate or whatever we're trying to do. So
You paid through the state, or?
we get variety of grants. That's how we're paid, federal, state, local grants. Because we don't charge for any of our services. So if somebody's a criminal, I send them to a public defender, and if they can't afford going to the magistrate court, we represent them if we can. They meet the income levels.
Yeah.
So you got some of these. Do you want me to bring in our stuff to share a table?
Yeah, you want to get it?
Did they want you to?
Table? Oh, you want to put, you want the table?
What's the table?
Could you send it to the thing to be here? Yes, thank you.
I didn't send you.
Okay.
I don't remember sending it. No. Oh, it's. I sent something for states to just have a table. Is this what it was?
That's for something different.
That was something different, yeah.
Yeah.
No, at this point, I don't know what's on the table.
Got one left over there if they want to clear it.
No, they got some of these out.
I guess it's
Oh, there he is. Big D.
So you could ask me anything else. I guess I can tell you about it.
Yeah, if they asked for anything, I didn't. Yeah, I didn't.
Like, you know, the stickies for the roll cards.
Is that your chair? You gonna put him in?
I'm not going to
I'm gonna go up and finish my presentation. But I'm Mayor. How you
Good
doing?
to see you. How you been? So good to see you. I think you're going in back of me. I'm going,
I got
I
mixed up.
think I'm right in front of you by the schedule. By the schedule. I got blue and then you.
Good evening, everyone. Good evening. We want to welcome everyone to the Roles and Responsibilities in Housing Workshop, along with our collaborative efforts with Richland County. So I'm Charmaine Fowler with the City of Columbia, Community Development Department, and this is I'm Nathan Jackson, with Richland County Community Development Department. Great, and we want to thank everyone for coming out, taking the time out to come and listen to our great panel that we have to share some great information with you. We are also streaming live, so hopefully, hey everyone, I'm streaming. We want to welcome my director, Felicia Kilgore, to come and let's introduce everyone.
Thank you, Charmaine. Welcome, everyone. I'm so excited to see that we do have some guests to participate in this session this evening. We was worried there for a moment, but lo and behold, we got some participants, which is excellent. This is our second session of roles and responsibilities workshop that we conducted. The first one was conducted last year in January. We have some great feedback from that same session, and so we thought it would be a great idea to do it once again to enlighten our residents, provide some good information to our tenants, and then also create a more collaboration effort with our partners that we have here today, and so that we can kind of put faces to where we need to contact various organizations and departments for assistance in regards to apartments and housing. So, just as Charmaine said, I'm Felicia Kilgore, I got to put my readers on, so I can read these names. I don't want to get the names messed up and call them incorrectly. But on our panel, thank our panelists for taking some time out of their schedule to participate in today's workshop. So I'm going to start from the very end. There I have Mr. David Hatcher. He is with our City of Columbia Code Enforcement. He's the Director of Code Enforcement. We also have Mr. Samuel Kramer. Thank you, Mr. Kramer, for joining us this afternoon. He is with he's an attorney, and he's with Southland Legal Services. And then we have Mr. Dunn Frierson. Mr. Frierson has been around for quite some time, very, very knowledgeable, and please ensure that you listen to the things that he shares with you, some great knowledge. He's with the South Carolina Human Affairs Commission. And then you have Ms. Regina Montgomery. She's with HUD. She is our regional relocation specialist.
Okay.
And in my former co-representative with SC Housing, we have Ms. Jennifer Morrow, of course, with the Southwest State Housing Finance and Development Authority. So I'm going to turn the program over to these guys, and then, of course, please feel free to ask your questions, any concerns that you have, if they need to elaborate a little further in terms of some of the topics that they're discussing. Please do not hesitate to raise those questions so that we can ensure that we're addressing the needs that you have, okay? Okay, we're going to start with Jennifer.
Good evening, everyone. My name is Jennifer Morrow. I am the Management and Occupancy Review Manager for SC Housing here in Columbia. And our department has a contract with HUD. And what we do is we work with residents who have concerns or issues along with the offices and the staff members at those apartment complexes, as well as the owners, to make sure that any concerns that you may have are heard, that you're treated fairly. We want to make sure that you're protected and that all of your needs are met, and that is what we're there for. If you do have a concern, we do ask that you reach out to your management office first. Give them a chance to fix your issue, make it right. And if they haven't gotten back in touch with you within a reasonable amount of time, then we do ask that you give us a call. If they do get back with you and say that they have to reach out to a vendor, do allow them some time to get whatever that information is back or whatever is needed if they have to order a part. Give them that time to get that situation rectified for you before you reach out to us. But if you don't feel like that is happening, we are your very next step. We do have 2 different numbers that you can reach out to do that for our tenant concerns. You can call into our main line, or you can actually reach out to Ms. Watson or Ms. Shaw Henderson. Those numbers are 803-896-9007. We also have an 800 number, which is 1-800-236-3994. And if you are unable to reach someone at those and you have to leave a message, you can also call into our main line. That is specifically for apartment complexes that are receiving Section 8 subsidy. So if you are not currently receiving Section 8 subsidy, if you call into our main line, which would be 803-896-9001, you will reach our reception. If you let them know what department that you may need or what your concern is, they can direct you to the appropriate parties that should be able to assist you, okay? So after you reach out to your management office and let them know what your concern is again, and then you don't hear a response back, and you reach out to us, our staff will speak with you, we will get some information from you, and then we will reach out to them, and we try to make sure that we have a response back with them between 24 hours. Unfortunately, sometimes that's not possible, or it may fall over a weekend, but as soon as we get that information back with them and they tell us what their corrective action is, our representatives and staff are going to reach back out to you and let you know what we were advised and confirm that that's the same information that was sent back to you. And if they say, for instance, they're going to be out to fix something in 2 weeks, and 2 weeks and 2 days combined, you haven't, we're going to say, give us a call back, so let us reach back out and see what's going on. Maybe there was a delay. So we can make sure everything is corrected in a timely manner for you. We all know that everybody has issues and concerns, and that's exactly what we're there to help assist you with. If at any given time you feel like any of those things have not been met, again, you can reach out to any of those numbers. We do have support staff, which is Mary Watson, and we also have Summer Shaw Henderson. Ms. Bonnie Roberts is our Director of Contract Administration. Her contact information, as well as our Director of Rental Assistance and Compliance Monitoring, are on brochures over at the Hood Table with Ms. Dusenberry, if you would like one of those. Does anybody have any questions today? Yes, ma'am. What you would need to do at that point is have the resident reach out to us, because we're going to have to clarify information that would relate directly back to them. Does anyone else have any questions?
Good evening. Again, my name is David Hatcher. I'm the Director of Code Enforcement for the City of Columbia. Today I will go over the Code Enforcement Division's involvement with rentals and what we feel are responsibilities as landlords and tenants. I'll certainly be happy to answer any questions afterwards. Next slide.
She can do it.
The Code Enforcement Division is part of the Columbia Police Department. We merged in CPD back in 2014 at the direction of the city manager. We ultimately report to the police chief, Skip Holbrook. We generally enforce anything you can think of that has to do with maintaining your property, and that can be anything from overgrown yards, trash and debris, abandoned vehicles, to substandard structures and unsafe living conditions. Many of these violations are found in the International Property Maintenance Code and the city codes and nuisance ordinances. We also enforce the city's vacant building ordinance and the rental ordinances in both, the rental ordinances, both long-term and short-term rentals. We have 21 inspectors that are assigned throughout the city at various police regions. I have a couple inspectors in the audience tonight. And we have inspectors assigned to specialized tasks, which could be the short-term rental enforcement or the long-term rental enforcement. And lastly, we have a work crew that is designated to abate code violations when we cannot get the owner to abate for us. The City of Columbia has a rental ordinance, as I mentioned a minute ago, that was passed in 2016 that requires all landlords to register each rental unit with our office. Today, we have nearly 27,000 registered rentals throughout the city and about 430 short-term rentals registered. During the registration process, the landlord must certify that each of their rental units meet minimum code. We provide them with a checklist, and at a minimum, among other things, the units must have working heat, water, and electricity. They must have smoke detectors and fire extinguishers, and the units and premises must be sanitary and free from trash and debris. The structure, interior and exterior, must be free from any defects or any life safety issues, and the unit must be free from bugs and pests. The ordinance also establishes a point system. The point system assesses fines against the rental permit for any violation of city ordinances. And these violations can be anything like what I mentioned before with the property maintenance code violations, but it also can be any criminal activity by the tenants or any other violation of city ordinances that will assess points. If the permit receives more than 15 points, the rental permit can be revoked, and the landlord can lose the privilege to rent that particular unit. The landlord is ultimately responsible for everything to do with the property, to include the general maintenance and upkeep, and the property, also responsible for the behavior of the tenants of the property. Tenants also bear some responsibility in maintaining the property. While the landlord is generally responsible for the structure itself, the tenant is generally responsible to keep the structure and premise clean and sanitary. Depending on the lease agreement, the tenants are also generally responsible to maintain the yard and ensure the grass is cut. Some other common issues that we see on rental property caused by tenants are we get a lot of parking in the front yard, road cars that are overfilled or brought out to the street before or after the day of collection, litter and trash in the yard, abandoned vehicles, and loud parties. or other obnoxious behavior that annoys the neighbors. If there are problems with the structure or premise, the tenant needs to notify the landlord so they can have an opportunity to fix those issues. They also need to allow the landlord, with proper notice, to come inside and fix any of those violations. I would also suggest any tenants become familiar with the Landlord-Tenant Act of South Carolina to make sure they know their rights and the proper procedures for notifying the landlord of code violations. We are also available to inspect the property. If you're not sure what's a code violation, you can call our office and we'll be happy to come out and take a look and tell you what the violations are. We'll do that at the request of the tenant or the property owner. The most important thing a tenant can do is be a good neighbor. Be respectful of your neighbors and keep your property in good order. The way you maintain your property can have a negative or positive impact on the community. Don't draw attention to yourself. This also goes for behavior. If you draw attention to yourself, then we're going to look closer and it's going to cause us to address more code violations. So if you don't stand out, then we won't pay attention. So it's important to note. The landlord can be assessed points and fines for failure to maintain the property and your behavior. So keep that in mind. If you cause issues, the landlord is getting fined. Always remember that although the landlord is ultimately responsible for everything that you do with the property and the behavior of the tenants, the fines are often passed down to the tenant. And sometimes the landlord can initiate eviction for bad behavior or criminal activity. So that's important to note. I think I'm behind the slides. So if you have any questions or need to contact us, we can be reached at our general phone number, 803-545-3430. That's the general line that if you have any code enforcement related issue, they can put you in the right, with the right inspector. Also, you can visit us online, columbiapd.net/code enforcement. There's an overview of everything that we do, code enforcement wise. We also have, and y'all can have one of these brochures, at least somebody passes them out. It's kind of the top 10 of what we enforce and what we look for when we do order properties. Remember, you don't want to draw attention to yourself, but if you do get our attention, we're going to look for all these things on that property. And then you can also visit us in person at 928 Hemlock. Our office hours are from 8:30 to 5, Monday through Friday, and that's right down by the fairgrounds. So that's all I have. Any questions, Don? Oh, yes, ma'am.
A question for David Atkins.
Yes, ma'am.
So, as the leader, if you recognize a home having some substance issues, and we don't know if it's going to property or not, and we still reach out to you guys will follow through?
Oh, yes, ma'am. The violations that we enforce, it's not just for rental property, we're equal opportunity. If it's privately owned or owner occupied, we address all these same issues on that property as well. So we just have an extra layer of protection for tenants to make sure they're living in safe rental units, but we cover the ordinances for every property in the city, commercial and residential.
And are you saying, when you said 37,000 units, is that apartment and home?
So it's total units, so that could be a single family home, so we can go from a single family home to an apartment complex with 300 units in it.
And how do you find about the system for the follow-up is, how do 15 points, 3 year, 5 year, how do you implement?
So for every violation that well, not just a violation, but any violation or criminal activity, every time there's an incident at that location, the first offense, it's an offense essentially. The first offense is 1 point, and then the second and each offense thereafter is 5 points. So by the time you've had 3 to 4 issues at that location, they could be facing eviction and losing their rental permit. So and it's $100 per point. So every time if we send a letter tell you to cut your grass or move your car out of the front yard, the landlord has already been assessed the point. So it's a $100 fee. So keep that in mind and you pass that down to the tenant. And that's all available on our website. If you go to the columbiapd.net, there should be some more information about the rental points. And or if you want to call our office, we'll be happy to tell you. If you have a specific property you're curious about what the points are, we can tell you that. Yes, sir.
One question. You mentioned that particular landlord accumulates a certain number of points, and then they lose the ability to rent that particular unit. What happens to that renter that's in there? Because I imagine that would be a question that people would want to know on that basis.
Yeah, so they'll eventually have to do an eviction. Generally, what happens most of the time with a landlord, especially if the problem is the tenant, which is a lot of the times the case, if the landlord starts the eviction process prior to reaching 15 points, we actually will reverse the points once they evict. Once they resolve the problem, then we can reverse the points. So very rarely does it reach the point where they've exceeded the 15 points, because usually the landlord wants to take advantage of it before then and do the eviction and take care of that. But in the fact that we actually had to go through, then they would lose, we revoke their rental permit, they would be illegally operating at that point, so they would have no choice but to evict.
So you force them into that process. Thank you.
Yes, ma'am.
Two questions actually. One question is, what are the guidelines in terms of a landlord keeping his abandoned car at a property that he's renting out?
I mean, that's ultimately the landlord's responsibility, so they would still get the point. I would hope that they're not blaming their tenants on that if it's their car, but the landlord's the one's getting the point anyway, so they would be the one responsible for the fine.
The second question is, in terms of having a tarp on someone's roof for year after year. Is there anything in regards to that?
Yeah, that's a code violation, and that really has nothing to do with rental or non-rental. I mean, any property that has a tarp on there is a code violation, so we would need to start a case if we don't already have one. And you can report, if you see something like that, you can report that to our 545-3430 number. Chances are we may already have a case on it, but don't assume that we already know about it, because there's so much going on in the city. Don't be afraid to call us and let us know about it. What else? Yes, ma'am.
So where are you, I know there was a rule on towing cars, it says, where are you actually doing it?
We are actually doing it now. I think when we talked last year, we probably were just getting started with it, but I don't have a number, but we've been actively, especially Miss Sumter back there. She doesn't like cars on abandoned cars on private property. She'll tow them in a minute on private property if they're in. There's a long process we have to go through. Well, it's not necessarily time, it's just a lot of steps that we have to take. If we towed a car, we've gone through numerous steps. I mean, you've had ample opportunity at that point to take action yourself if we reach the point of towing a car. But I don't have it in front of me. I know it's something like we try to issue a summons, we take 3 attempts to issue summonses.
Can I explain it to her, because she's asking specific questions?
Yeah,
I'm sorry, I
we'll catch
don't
it
mean
at
to
the end.
overstep it.
Charmaine said we'll catch it at the end.
Okay.
Thank you, though. We'll catch it at the end.
Thank you.
Yep.
Next slide for me. Got mine up?
You are evictions, right?
Yes. Thank you. Good evening. I'm Samuel Kramer. I'm an attorney with South Carolina Legal Services. So let me begin by telling you what we do, what our mission statement is. We're a statewide law firm. We provide civil legal services to protect the rights and represent the interests of low-income South Carolinians. We represent tenants. We do not represent landlords. Next slide, please. South Carolina Legal Services is not a state agency. Could you advance it, please? Excuse me. Thank you. We're not a state agency. I had a question earlier today. We're funded by federal, state, and local grants. That's for our funding. We do not charge for any of our services. Next slide, please. Who's eligible for our services? Low-income residents of South Carolina. There's a limit on income, 125%. The federal poverty level, that can go higher with a waiver. That slide's pretty self-explanatory. That's part of our intake process. Usually reach us 24/7, we're online. Usually call us Monday through Thursday between 9 and 6 p.m. on our intake line. There's some exceptions, and I covered that. You can read the slide. Next slide, please. Okay. Applications, here's how you can call us. Our telephone numbers, I just mentioned, we're online. You can email us. The big thing, though, is you can always apply for our services 24/7 online if you can't get through on the telephone lines. Next slide, please. What do? We represent in legal proceedings. I'm in the courtroom, I'm in a housing court. Columbia does have a housing court. Okay, it meets usually 2 Thursdays a month over on 2500 Decker Boulevard. We do counsel and advice. Next slide.
Go ahead.
Okay, so I mentioned we're in the courtroom in the housing court. We do counsel and advice. Some cases, others we can go a little further, write letters, make phone calls. In some cases, we do end up directly in court. And that could be at a magistrate court. It could also be in the court of common pleas, depending on the case. What do? Community education, brochures. I've got a table on your left. Make sure you stop by and get some of our brochures so you know who we are and what we do. Next slide, please. What we do not do, we don't do criminal cases, and we don't do fee-generating cases. What does that mean? I can't go to court and say, give me this much money from the landlord. We're not allowed to do that. That's what a fee-generating case is. I have to refer you to the South Carolina Law Referral Service, or you can go to private bar and you can represent yourself. But I can't go into court and say, give this person X amount of money. Next slide, please. Evictions for lease violations. Let's talk a little bit about that, because that's one of the things we see in a lot of cases. So Jane Jones resides in public housing, rental, receives Section 8. Son's arrested for illegal drug possession outside the neighborhood. Landlord applies for rule to vacate. Another kind is, notice it's public housing, not private, operated by the Public Housing Authority. 16-year-old son arrested for illegal drug possession outside his neighborhood. Landlord applies for rule to vacate. Same result? Nope. Result can depend on the type of housing. You have more rights in public housing than you do in private housing. What do I mean by that? From the Housing Authority, you can have a meeting, an informal or formal hearing, and go through those steps before you even get to the eviction. Okay? So it depends on what kind of housing, location of the activity, other program rules. And we also have, for example, house rules in addition to leases. Some landlords have them, some don't. Those house rules can supplement a lease also. Okay, next slide, please. Types of public housing. Let's talk about that for a minute. Well, conventional public housing, that's part of the Housing Act that passed. Low-income families earning below 80% of the area income. Rent is usually 30% of the family's income, adjusted for medical and other expenses. Only been operated by the local public housing authority. City of Columbia, Columbia Housing Authority. Must be operating in compliance with United States statutes and the HUD regulations. It also includes housing for senior citizens, persons with disabilities. Next slide, please. Let's talk a minute about rental aid. Section 8 rental assistance. Okay, low-income families, single individuals, tenants choose the units in the private market. Incomes are less than 80%, rent is usually 30%. Assistance may be project-based or could be tenant-based. Housing choice vouchers. Funds may be targeted to veterans, elderly, disaster victims. Next slide, please. Other housing programs. Rural housing services. That would be low-income housing tax credit, homeless assistance programs. Next slide, we're on eviction issues, please. Okay? Let's talk about that, because that's going to be the focus of my presentation. Let's talk about that a lot. Because I'm in magistrate court representing people in different counties around. We're about 6 to 7 counties. We're operating from the Columbia office, but we're in counties adjacent to Richland, Lexington, Kershaw, Lee, Newberry, Aiken, to give you examples of how far we go to court and advise people. Can a landlord evict for no cause? Public housing. You can't be evicted without good cause and without notice and opportunity to be heard in public housing. Applies both to termination and renewal of leases. Let me speak about the leases in private housing for a minute. I got a lot of questions. In private housing, a landlord does not have to renew a lease, nor will a court order a landlord to renew a lease. Cannot be forced to do that. Okay? Okay, public housing applies both to termination and renewal of leases. The landlord in public housing must prove serious or repeated violation. Material terms of the lease: over income, not reporting your income; criminal activity, alcohol abuse, failure to comply with the program requirement. Section 8, voucher individuals, they can be evicted without good cause at the end of the lease term. Project-based tenants cannot be evicted without a good cause. Landlord must prove serious or repeated violations of the terms of the lease. Drug-related activity, owner of the premise, criminal activity, those type of things. Next slide, please. Let's talk about drug and criminal activity. Tenants can be evicted for drug-related criminal activity on and off the premises in public housing. Our staff, flight to avoid prosecution, alcohol abuse, which disturbs residents, violation of parole and probation. Sex offenders are not allowed, for example, to come onto public housing, visit, any other issue like that. Section 8, you can be evicted for drug-related criminal activity on or near the premises. Criminal activity disturbs other residents, neighbors or staff, flight to avoid prosecution, violation of parole, a lot of different things. Next slide, please. Other good cause to evict. Why are people being evicted? Well, public housing, let's talk about it. Application fraud when they apply. Failure to perform community service. Subletting or allowing boarders to stay. Failing to clean the unit. I get people with housekeeping violations. Violation of community rules. Damaging the unit. Refusing to pay repair damages. That's public. Let's talk Section 8. Private landlord, Section 8 voucher. Disturbing the neighbors, damaging the unit. Owner's desire to make personal or family use of the unit or removed from market. People out. What's the lease up? Business or economic reasons to terminate the lease sale, increasing rent, renovation. Let's talk about other good cause to evict and tenants' rights. What do I see a lot? I'll tell you what I see a lot of. People call me and say, well, I was only late in paying my rent 1 month. I didn't pay for this month, but I'll pay for both months next month. In South Carolina, unfortunately, one time being late, one time not paying the rent, you give the landlord grounds to evict, and there is no legal defense in court. I can't raise it. Judge looks at me, sorry, Mr. Kramer. And that, what I mean by that? Economic argument, I lost my job. Hardship argument, I went to hospital. This person died, they moved, they got divorced. Doesn't matter. Late or non-payment of rent, no legal defense in this state. Other states, yes. South Carolina, no. Withholding rent. The landlord won't make repairs, so I'm not going to pay it. Sorry. In this state, you withhold rent, you give the landlord grounds to evict you. And there's no legal defense for that. Third usual reason, failure to maintain the unit. No legal defense for that. Lease violations is a little different matter. And that might be something the landlord's trying to show the lease was violated for some type of activity that occurred. That may end up in front of a judge, require proof for that. As I just said earlier, the landlord does not have to renew a lease, nor will a court order this. Let's talk about tenant rights in here. We talked a lot about what happens, but a tenant can request a bench trial. If you don't respond once you're served with that rule to vacate, you get 10 days. Let's tell people, do what the court tells you to do. They say respond, come back and respond, say, I want a bench trial. What does that mean? A judge decides whether you go or stay. A judge only. What is a jury trial? It means you will get a jury of 6 people, not 12 in magistrate court. In Richland County, that may take 6 to 12 months before that trial is actually scheduled. Depends on the court. You have to request in writing, not later than 5 days being served. The court likes to use calendar days, not business days. Okay? What's a bond hearing? You request a jury trial, the judge says, we're gonna have a bond hearing, that's to preserve your right to a jury trial. That's usually the amount of rent you pay every month, or if you're behind in rent, the judge could order you to pay the arrearage as the bond to preserve your jury trial, along with paying the rent every month. Once that judge sets that bond, you don't pay it, they just issue a writ of ejectment. No hearing, that's it. Mediation in Richland and Lexington is required before a jury trial. There's a mediation court actually in Lexington, I've been there. It's a well-run court. Richland also requires, Richland County, mediation before a jury trial. Why? Trials take time and money. If it can be worked out in mediation, court likes that. Okay. One thing I notice is you have to give a tenant notice in writing to evict. And a phone call won't cover that. It has to be in writing, okay? Now, I've got a lot of questions on sealing the record. Oh, Mr. Kramer, it's like what would you say, a bankruptcy. It comes off after 7 years. No, it doesn't. It does not come off. The only way it can be taken off is if a judge seals it, and they don't have to. The rule doesn't require them to. Some judges will, some won't. We can ask for it, but some say, no, Mr. Kramer, I'm not doing that. That's that. So I advise people, get a copy of the court order showing your case was settled or dismissed if you can. But if it's eviction, it's an ejectment, it's not going to be sealed, it's going to stay on your record. Long-term impact on credit, of course, FICO score. So I just tell people, once a year you get the credit report. You can order one from those 3 big reporting agencies. You get your free report, take a look at it. The other thing I always advise folks to do is go to the magistrate court and look at the court file. What does that mean? The landlord has to go to the magistrate court and say, I want you to evict this person. Here's the lease, here's the tenant ledger, here's my affidavit, whatever else they want to put on there. You as a tenant are allowed to go to the court, look at the court file, and make a copy, or pay for a copy of the court file so you see what's in there. Okay, so I've talked a lot about, next slide please, the system that we live under with South Carolina Legal Services. And I look forward to talking with you and answering your questions. Again, I cannot give specific legal advice, but our brochures over there will tell you what we can do and what we cannot do. And we'll hold all questions for the end, so thank you for coming tonight. I always appreciate coming and discussing modernization and the good work we do every day for the low-income citizens of South Carolina. Thank you. Question. If I have a car in my car,
You have to talk over it?
well,
The tarp itself is not a violation, but it still has to be currently, it has to be registered in Albert.
okay, well, my top has not tagged, so, yeah, okay. I'm here to talk about fair housing and some of the things I'm going to say right now in contradiction with what he said, but we are enforcing 2 different laws. It is in South Carolina, our South Carolina Fair Housing Act. What our South Carolina Fair Housing Act states is you cannot discriminate against an individual in housing because of their race, sex, national origin, religion, disability, color, or related status, meaning that the person has children. This law has been in effect in South Carolina since about 1989. South Carolina was one of the first states to become what is known as, I can't think of the term, but we are compared to HUD. So our law is similar to HUD's law. Now, what does that have to mean in practical terms? It means that if you feel that you've been discriminated against, you can file a complaint with us. And he was talking about landlord-tenant issues, and he said there's really no legal. If you pay your rent late, you're gone. If you violate your lease, you're gone. In most cases, you are gone. But what happens if you pay your rent late and you get an eviction notice? And next door neighbor who is of a different race or sex than you
And they pay their rent anytime they want to. Now, you may pay your rent late, and then they file an eviction on you, but if they don't treat the other person the same way, then we have an action to file with us. And we will go in and investigate. And if that is the case, then the person who is paying their rent late and the eviction has been filed against them, we will stop that because you have people, two tenants who are being treated differently. Now, here's one of the things we see all the time. Anybody here on Social Security? So you get your checks different times of the month, right? Okay, suppose you rent a unit where it has to be paid by the 5th of the month. But you get your check on the 4th Wednesday of the month. That's the only time you can pay it. If you pay your rent on the 4th Wednesday of every month, should you be considered late? No.
Nope.
If you are on Social Security and that is your only source of income, and you have to pay your rent on the 4th of the month, legally we cannot charge you a late fee. We just settled a case like that. We just did it today. The lady was paying her rent 4th Wednesday of every month. They were charging her a $100 late fee every month. And we stopped that. You can't do that anymore. You have to take it off her record. And they have to kind of pay her back for all of the late fees that they have been charging her. So that's something to keep in mind. The other thing to keep in mind is the most of the cases we investigate are cases involving people with disabilities. And when I say people with disabilities, most of the time that comes to people who have service animals. If you're disabled and you need service animal, that's an animal that does something, like a CNI dog, a dog that can sniff out people who have seizures, who can alert people to that. They do have dogs that do that. If you have a disability and you need an animal, they have to let you have it. The animal can be a pit bull. So we have situations where people have a disability and they will not rent to a tenant because they have a pit bull. Now I don't like pit bulls, to be honest with you. I don't. And I hate to get those cases because every time we have those cases, we have to go down and look at the animal. And I'm terrified of pit bulls. But no pit bull is good meat, so I guess it must be all right. We've had cases where people have been denied a unit because the service animal was Rottweiler, pit bull, Carnivore, or whatever those dogs are called. And the thing is that those dogs are dangerous and there's an ordinance in the county and the county says whatever. They can't do that. They can't. In most, I have never seen a service animal that has bitten somebody. Now they might be out there, I have never seen it. The other type of animal is an emotional support animal. And this is basically the animal that doesn't do anything. He's just there for your emotional support. You just lay around and you look at him and you're happy. You have to have a doctor's statement in both of these cases. And the doctor's statement has to state that my client has a disability and he needs his animal. You cannot be asked the nature of your disability. The landlord can't ask that. Number one, it's none of their business. Number two is they cannot ask that. So if you have any problem with that, call us and let us know. Those are the cases that we see most often. When they establish cases, people who have children, one of the things we used to see is, say you have 4 children, and you want to rent a 2-bedroom house. Well, you got 3 don't. And they'll say, well, I mean, 6 children. They'll say, well, the unit is not big enough. And a lot of times what landlords do is go by, they say heartbeats, 2 people per room, that kind of thing. Which is all right. But the law says, if your house is big enough to sleep somebody in another room, you cannot limit yourself to 2 people per room. And we've actually had a case where, I think this was down in, well, I'm not gonna say the county, but anyway, the lady had 4 children, and it was, I forgot the size of the building, but the argument was the size of the apartment was too small. Well, we go down there, and that's one of those cases we have to measure and all this other stuff. But immediately when I walked in, I knew this was going to be a cause case, because the living room was all big as all get out. You literally could sleep the whole family in the living room. And the lady, she worked it out where she had children appropriately in the rooms, and they insisted that one place is too small. And we said, no, it's not, because you can sleep some of those children in the living room. Which is what we used to do a long time ago. You can sleep some of the children in the living room. And we wound up considering that case for the lady. Race cases, we do see a lot of those. Basically, someone will argue that they're putting me out for doing this particular thing, but my next door neighbor over here who is black or white or green or yellow, they're doing something differently. They're doing the same thing, but they're not getting charged. Now, typically in cases like that, we'll go to the magistrate's court as soon as the landlord and letter, asking them not to evict the person until we can investigate it. Now, if you bring an allegation like that, then you have to provide the evidence. Okay, what's your neighbor's name? How do you know this person is being treated differently than you? Then we have to go and talk to the landlord, and we have to put in records. And a lot of times, we really have to walk around the neighborhood and interview people. So I hate these cases in the summertime because it's hot. We really have to go around and walk through apartments. And, well, how's this landlord treating you? How are you being treated? And we have to do so many black or white or whatever. So we have to have good comparisons. So when people make those allegations, we don't take their words and allegations. We don't represent them, nor do we represent the respondent. And we've been cases where people have been evicted, tried because of code violations. Well, my car has been broken down, and this other person next door, their car has been broken down for 2 years and they hadn't done anything. So we have to go in and investigate those cases. Now, if the person feels that they've been discriminated against, they have 180 days to file a complaint with us. If they miss our 180 day deadline, they have an additional 120 days to file with HUD. So if this is like 200 days, they can file with us and we'll send it to HUD for investigation. We typically have 100 days to investigate a case, but a lot of times it don't work out that way, even because the respondents just want to be mean and don't want to answer the complaint, which means that we have to go get a subpoena and make an answer. The case is so complex, it just takes additional time. If it's over 100 days, we have to send a letter out stating that this case is going to take more than 100 days. That housing laws are very serious, and they're very serious because if we find discrimination, we can take a person to the court on behalf of the state of South Carolina. Now we've got some nice settlements, 8,000, 10,000, 15,000, depending on the severity of the situation. So it's very serious, And as a result of filing a complaint, two things can happen. It can be conciliated, meaning the landlord and the complainant get together and they work out an agreement. And when we conciliate cases, it's not just something that's on paper. The respondent has to go through training, there are certain conditions that they have to meet, and if they violate that agreement, we can open up the case again and probably take it to court. Our case can be no cause, meaning that, you filed this case for no evidence, so we're going to dismiss it. Or, as I said before, we can take it to court. Most of the calls we get, if I get 10 calls a day, 6 of them will be landlord tenant. So I'm going to kind of break myself in landlord tenant. I spend more time talking about landlord tenant than I do fair housing. But I'm glad you're here, I can shut them over. With a line, I just tap it better to shut them over.
I serve time to the end of this gentleman.
I was saying,
Referral. Here we go.
So the importance of fair housing in South Carolina is real. We take our job very seriously. And again, my number is 803-737-8830. 803-737-8830. You can call me mom because I don't get in office. But I would encourage you to give me a call if you have any problems, if you have any questions, because fair housing violations are something we really take into consideration. And finally, everybody in this room is a member of a protected class. Everybody's a particular race, everybody's of a particular sex. Young or women might become disabled. Some people in this room have children. Not just kids. So, if you believe that you have been discriminated against, and the law says, if you believe, not if you know. Because a lot of times you've been discriminated against and don't know it. So if you believe that you've been discriminated against, give us a call and we'll take a complaint based on that belief. But remember, the case will be investigated based on the facts. Thank you. That's all I have. I'll be here to answer any questions.
Last but not least. Hello, my name is Richland Montgomery. I am with the Department of Housing and Urban Development. I'm the Regional Relocation Specialist for HUD. Next slide, please. That's my contact information, so please don't hesitate to reach out to me if you have any questions related to the Uniform Act, and I'll explain a little bit about what I do with this particular law. Next slide. Just a quick agenda, just highlighting some of the things I want to cover today. I'm going to cover who we are, what we do, what is the URA, highlight some of the URA requirements that protect the rights of those who are impacted by a project, a federally funded project. Tenant responsibilities, agency, landlord responsibilities in the relocation process, and also I'll cover any questions if there are any questions that you have. Next slide. So who we are, next slide. Currently, I'm in the Office of Community Planning and Development, also the Office of Affordable Housing Programs, and my division is called the Relocation Real Estate Division. Currently, we have 4 staff members in headquarters in DC, and currently at this point, we have 5 field-based regional relocation specialists. Next slide. Ooh. Oh, go back. It's just, this is just, yeah, okay, covered. Next slide. Yeah, all right. So my division has departmental delegation for policies and guidance related to the Uniform Act. Although we're housed in the Office of Community Planning and Development, our department has delegation departmental delegation, which means that we provide URA guidance across all of HUD's programs. As you can see, we deal with public housing, community planning and development, Indian housing, as well as multifamily. So we cover the entire department. And we also provided advice and guidance on Section 104D matters. But Section 104D only applies to programs in the community planning and development specific to community development block grants and the home program if there's demolition activities or conversions of real property. Next slide. Okay, just to highlight some of the responsibilities. Oh, it's frozen. Okay, some of the responsibilities that we do, we coordinate with Federal Highway Administration. They are the lead agency for the Uniform Act. We develop policies and advisory materials. We review clearance documents if we need to review anything departmentally. We also provide URA and Section 104D training. So if you need training, I'm more than happy to provide that to you. And we offer technical assistance to any of our customers and HUD staff. And we also monitor community planning and development programs and projects. Sorry, my slides are stuck, but I'll continue. So what is the URA? URA basically stands for Uniform Relocation Assistance and Real Property Acquisition Policies Act of 1970. So no, it's a mouthful. It's also known as the Uniform Act, as I stated. The whole purpose of the act is to establish minimum standards for federally funded programs and projects requiring the acquisition of real property or the displacement of persons from their homes, businesses, or farms. It applies to all federal funded projects anticipating or receiving federal financial assistance that involves an acquisition, demolition, or rehabilitation project. And some examples, I had some nice, beautiful pictures to show you. That's okay. Typically URA is triggered when there's projects involving rehabilitation of residential or commercial properties. New construction, a lot of people don't think about URA being triggered in new construction activities. So basically in new construction, how it applies in that particular project is it applies to the acquisition of the land, even if the land is undeveloped or it contains no structure. Okay. Also, public facilities and infrastructure projects also trigger the URA, especially if you need access to utilities or water and sewer lines. Typically that involves an acquisition of land or easements for a project, which is also subject to the URA. And demolition projects also triggers the URA. And specifically with the demolition projects, if you are using community development block grant funds or home funds in a demolition project, that is going to trigger Section 104D, as I mentioned earlier. And just briefly, that particular requirement is only applicable in home or CDG. So what happens if you are a tenant that is required to move temporarily? Well, all of the conditions of your move must be reasonable. If your temporary unit must also be comparable and found to be decent, safe, and sanitary. Last year, June 3rd of 2024, Federal Highway Administration actually published a new final rule So we're in the process of developing implementation guidance on that. So one of the new requirements under temporary relocation is that it also recognizes a person who's temporarily relocated as a displaced person. So that's a new requirement. And also what you're entitled to is reimbursement for all out-of-pocket expenses, and the agency is required to pay for those expenses. The tenant also must be informed in advance of any rent increases or any offer of a different unit when they have to move back to the property. And lastly, your temporary relocation must be less than 12 months. If it extends 12 months, the agency is required to contact you and offer you permanent relocation assistance. Now, what happens to you if you're permanently relocated? Well, you are considered a displaced person, and you're entitled to be properly notified in a timely manner. You're required to receive relocation advisory services to relocate successfully. You're also entitled to receive moving and related cost reimbursements. That reimbursement can be covered either by actual reasonable moving costs that you incur, where you can actually submit your receipts and you can actually get all of your actual moving costs covered. Or we also have something called a fixed payment schedule, where we look at the number of rooms in your home and we can base your moving costs based on the number of rooms in your house. You're also entitled to a replacement housing payment. If you're a homeowner, if you're a renter, you're entitled to receive rental assistance payment at 42 months. And you also have a right to appeal your eligibility for relocation assistance, and the amount of that relocation assistance being offered to you. So what are some of the tenant responsibilities when you are required to move temporarily? Basically, if your responsibility as a tenant when you move temporarily is you must continue to pay your rent and comply with the lease while you're temporarily relocated, to avoid evictions. And also you need to stay in communication with your agency. And please don't move without being appropriately advised in writing. And also, if you're temporarily relocated, just please report any housing conditions before moving. So some of the landlord responsibilities that I want to cover at this moment in the relocation process. We advise that all landlords or agencies who are actually implementing the relocation process, we encourage you to plan and budget early and prioritize minimizing displacement and HUD-assisted projects. We also encourage you to evaluate your staffing and other resources needed to undertake before you undertake any acquisition or relocation activities. Also, we want you to evaluate your costs to the project and the people that are involved. You need to know who's going to be displaced, who will not be displaced, who will be temporarily relocated. You need to identify the availability of various advisory services in the area so you can appropriately advise whoever's impacted by the project so they can have available advisory services. This is not an option, it is definitely a requirement. Also, we want you to identify available comparable housing in advance of the relocation activities. And we also want your project files to be documented in sufficient detail to demonstrate compliance that includes your property acquisition and relocation activities. Please keep your acquisition and relocation records for at least 3 years. HUD program retention period may be a little bit longer. We also encourage you to track your tenants during the temporary relocation process. And landlords must also remember that you can only evict a person for serious lease violations and not for failure to move or cooperate with the relocation process. If evictions happen, it must be documented very well. We also want to encourage you to familiarize yourself with this new rule that was launched last year, but as I stated earlier, we're in the process of developing guidance on that. So just please stay tuned. Please reach out to me if you're a grantee. If you want to learn more about this new rule that is most definitely going to impact you. So please don't hesitate to reach out to me. So that concludes my presentation, and I'm sorry that my slides got stalled. Yeah. So if there's any questions, please ask. Yes, my phone number is 803-253-3008. 803-253-3008.
So this kind of concludes the informational part. Does anyone have any questions for our guests on the panel? Sure.
For legal, so we deal with a lot of people that buy houses that need to go through probate but haven't quite gotten there yet. Most of them would qualify for the assistance. Do you walk them through the steps, or you just say, go file probate kind of thing? That way you like direct them?
Well, to understand, we do all different types of civil, and we have an application on our website to apply for someone that needs, for example, before probate, a will, a power of attorney, healthcare power of attorney, durable power of attorney. We provide those kinds of services, and we do have some attorneys that go to probate court. Not all of us go to the probate court. Excuse me. Not all of us go to the probate court to answer your question, but I can't give specific legal advice. But I do encourage people to apply on our website 24/7. Download your question or your documents so you can begin the intake process. That's what's part of it. Another question for any of the panel? Well, they gave you the microphone. I do refer people. Oh, we got one?
There's one in the back here.
Okay.
Not enough. Okay, we know that everybody's living situation is a bit different, and earlier you mentioned that tenants who receive disability is not considered late, as that is their only source of income, which will come after the initial due date. So my question is, does this still apply to household incomes that is not disability, or if the disability is received prior to disability?
Usually this applies to, if you're the only person in the house and the disability paycheck, your check, is the only source of income, then it applies. Now, if you have other people in the house and you have other income in the house that can pay the rent by the bill, then that's what you should do. But if that's your only source of income, they have to allow you to pay the rent when you get your Social Security check. And a lot of landlords are not up to date on that, so we see that a lot. And people have been sending eviction notices. And one of the reasons why we try to, because it's hard to get an eviction off your record. It's real, I don't even know if people even get them off, to be honest with you, but it's very hard. And so we try to stop that before they get to that proceeding.
How do they notify so that people know, okay, like they come in, they have to go through agencies to notify them, direct communication?
Well, I think you should communicate that with your landlord, because most recipients are made by the bill. If the Social Security disability check out, Social Security check comes on the third or fourth, and I think it's about Social Security numbers as to when, you should let them know this is your only source of income.
And if they're not compliant, then I contact your agent.
Please, they'll be compliant. They will, no, seriously, they will.
So part of that is when you are signing your lease, when you go in to make that application, my check comes on this date. Do you understand what I'm getting paid to pay the rent? As Mr. Ferguson said, there are exceptions to the rule. But those are why I refer people to Mr. Ferguson and Mr. Hatcher, because I'll ask questions, is this happening to you? You may want to contact this agency or code enforcement in addition to what we're providing. They will do their own investigation. They will conduct their own inquiry in addition to what we're doing. Or they'll send people to South Carolina Legal Services from all agencies that refer them to us. So we can begin the process of looking at the legal problem and seeing what other agencies can be involved in assisting them.
Yeah, we just settled a case like that today. Really? Who said that? All right, there's something that's called written accommodation. Right, written accommodation means that whatever policies you have, you waive those policies because of the person's disability. So the fact that they don't allow animals on the property, that is not an excuse not to allow somebody to have a service animal. And we've seen that also. Well, we don't allow pets on, well, you don't have to allow this pet on the property. I mean, we don't talk like that, but, I'm just saying. And the other problem comes in if the animal, as I said before, is considered a dangerous breed. That's just too bad. I mean, if the dog bites somebody or tears up a property, you can get rid of it. But again, I've never seen a service animal bite anybody. And we have to go down and look at it. And I hadn't been bitten yet, so maybe it's not like me, I don't know.
And it was actually for a long period of time, and we did a lot of homeless people, there's people that are not living in the house because nobody is supposed to get.
HUD houses, empty homes.
I think I'll answer that one. To the best of my ability anyways. Anytime you have a situation like that, it doesn't really have to be a HUD home, or it could be any home in the city of Columbia if it's vacant and you have vagrants sort of hanging around inside that should and they're not supposed to be. Certainly report that to the code enforcement office and certainly call the police department if you see that. All houses need to be, all structures need to be secured. So if you have a building that's hanging wide open and people are going in and out of it, that's a code violation. So you certainly want to alert our office of that and we'll address it.
And I'll kind of explain a little more.
I'm not in the city, I'm in the
Yeah.
So if it's like a single family home that is like abandoned and you believe it might be like within HUD, it might be a home that had a HUD insured loan on it and that went into foreclosure. So then HUD is going to go through a process to get that, like to close that foreclosure. But besides that, there wouldn't be any like HUD-owned properties per se, because it's like with rental assistance, it's either going to be public housing, or it's going to be a private landlord, or it's going to be like a private multifamily
You might be talking about
complex.
South Carolina Housing Authority. They own a lot that are vacant.
So that would, if it's with SC Housing, I would also contact SC Housing regarding that.
Okay.
But with if it's like a house that had a HUD insured loan that went into foreclosure, like he said, I would contact code enforcement.
Excuse me, but I have contacted, that's why I'm here, because I have contacted, and Ms. Gibbs, Ms. Gibbs and another guy came out that was responsible for the house. And she told them to do, I guess it was contractor, whoever it was, told them to keep up the house, but they're not doing what they're supposed to do. And I don't feel like I can keep on the same, all the time, doing the same job that I called them 2, 3, 4, 5 times. And I was going to code enforcement. I was going to, I'm already down the street lawyer at the library. I have done these type things to resolve the issue. And I just want to know who I really need to talk to get the job done.
Yes, ma'am. It sounds like your issues in the county, so I can't really answer to the county processes on that, but I would say if it's anything in the city of Columbia, if you feel that any of my staff is not doing what they're supposed to do, you call me directly and we'll get that addressed. But I would always encourage you, if you feel like you've reached out to all the appropriate people at the city or county, I would say you got to contact your local county council member or city council member. You certainly can get a lot of action that way whenever that happens. But out of respect, I would ask you, at least if it was in my area, I would ask you give me an opportunity to address it first before you did that. But certainly if I'm not doing my job, then feel free to call your local city council member and let them know what's going on.
Yeah, I mean, I've been doing this, over a year now, just trying to verbally, go in and then I started to put things in writing, certification and all this good stuff. And I do have a, as a community, trying to, do a better job. We want to do
I also want to encourage you to reach out to your county council member. If you feel like you've already notified everybody, that'd probably be your next step.
Yeah, my question was back to Mr. Bryson. You said that the landlords can't ask about your medical records when it comes to motion support or service dog. So is it best we get a form from our doctor originally, or is there a special form we need to have to apply?
You can get a statement from your doctor, but the statement should say this person has a disability and they need the animal for the peaceful enjoyment of the premises, or something to that effect, but it doesn't have to state your disability. And the reason why landlords will ask for that, because, and this is very important, one thing that a lot of people used to do is they'll get an animal and all of a sudden they become disabled and they need a place. So landlords and HUD approved, they can ask for this information. Now, what a lot of people will do is they'll go online and get some kind of statement from somebody online. And we used to get that a lot. So what HUD said is, you have to have a relationship with that doctor. In other words, you can't go online and they talk to you one time and get a statement. Because when it comes to us, we're going to ask you, how many times have you seen a doctor and do you have a doctor-client relationship? Well, they can't ask you for that, but you don't have to review the disability because we wouldn't know their business.
So when you say relocation, why would the person have to relocate?
Yes, the Uniform Act applies to individuals who are impacted by a federally funded project. Okay, so HUD or any agency may receive federal financial assistance to do a rehab project, an acquisition project, or a demolition project. Okay, if those properties are occupied, tenants, homeowners, businesses, are entitled to relocation assistance under the Uniform Act. And so, yes.
Okay, so
Mayberry, you use it as an
Hmm?
When Mayberry,
Right. Say that again?
the housing complex, right, would that be an example? That's what she's
I'm not familiar with that.
It's a
Like,
huge housing complex that they basically got everybody else, so they can upgrade it.
if they use federal financial assistance, yes, everyone is entitled, if they're gonna be permanently relocated, they're eligible for permanent relocation assistance. Now, if tenants are temporarily relocated, they still are protected. So, they receive moving assistance. They receive, if they're temporarily relocated, they can actually receive, the agency has to pay for them to move in a temporary comparable housing. So, what you got?
Okay, right, because I know somebody, I just thought this was because you're saying the system set up to help them find somewhere they can go while
There's a law that protects them. Yes, if there's federal financial assistance involved in that project, and if they were required to move, they were entitled to relocation assistance. So please call me, 803-253-3008, and I will look into it. Yes, ma'am. No, if there's no federal funds involved, no. Now that they're making,
So there was a property that was condemned, and the client.
that was more likely a code enforcement violation. In some cases, URA may be applicable, but that is very fact specific, and I would have to look specifically into that to determine if those occupants were actually eligible for relocation assistance. Code enforcement violations are a little different, but like, as I state, the URA is very fact specific, and then I would have to look into the specifics.
Yeah,
Was it related to a code violation?
Code violation, but that was the saying, okay, that was
In most cases, code violations won't trigger the URA, but there are special cases, and then I would have to look into it. Yes, ma'am. Oh,
Anyway, I'm going to piggyback off the question about moving away from the area. You're supposed to be living in an apartment, so I am actually to move out of the apartment every time. There's an you're not, we supposed to start hard. April now, so my thing is, why can't we hold time? Looking on this apartment, looking on the renovators, I'm about to get old, so, you know. And, yeah, and a lot of more that. But I'm standing, good standards and trying to do good in there, but, you know, I'm just trying to find out why. And another question. You can answer that.
now if it's a housing condition situation, like mold, and if they did not use federal funds to actually do the necessary repairs, then URA wouldn't apply. Okay, But if they did use federal financial assistance to do the necessary repairs, then the tenant occupant would be, maybe eligible, let me just say that, may be eligible for relocation assistance, but I would have to look into the facts of what truly transpired in your situation.
I don't know what's going on in between the walls and my property, but it's like road in there. I emailed them. Then, like I said, it's supposed to be doing the renovation. Now, another thing I want to ask when it comes down to the tenants. Are they supposed to, because what I want to know now, my landlord's tenants rules and regulations. Anytime I had, with the garage up, sitting in the front, sitting in the garage, they cooked it. That's in the trash, just bought it for $75. Now, one letter, a notice, manager, if anybody says anything about that grill couldn't be there, just get it. They said it was not by my fault. But anyway, so where are we supposed to keep the grills? Are they supposed to go in those people that have been on like 94 years? So and on your behalf too, when it comes down to all of that, we supposed to have meetings, give updates on things that are going on, like I said, about higher, you asked me about higher things. But when it comes down to what we need, management's supposed to come in, talk to us, bring whoever they need to bring it in, talk with us, give everyone letters. Oh, that's not the highlight was my car was told with a handicap back on too.
What?
Yes. They can get that back. No letter. The day time I had to slap the green sticker on it. And the reason why we had to park in whatever park was, again, the garage was leaking water, they had to block it off. So we had to get in what we could fit in. We had guests parking in the garage, so that left us with no cars, unsafe grounds, no cameras out there. My car got vandalized out there. Nobody did anything. So this is what's been going on. So I'm not just telling them about all of that. No questions about that, no answers. Good to do your car. You know, I want to know, are they supposed to be sending us letters out, informing us of everything there's a problem, there's leaks going on in the building. Okay, we got leaks in here, y'all been parked right here.
So I'm gonna try to answer some of that. So do you live in an apartment complex? Okay. So the fire, and I'm not an expert on the fire code, but I'm pretty sure that you're not allowed to have grills in any apartment building. I think that's a fire code. So you're not allowed to have anywhere on the premise. I couldn't tell you more than that, but I'm pretty sure that's a code. You just can't have a grill in an apartment complex. Now, if you had a private residence or you rented a house or something, you should be able to have grills, no problem. I would also say that if all those code violations you mentioned to us, even though you think the landlord is handling them, if you don't think they're handling them, I would certainly reach out to my office. And that could be even if it's owned by the housing authority or whoever, we still should be involved in that process because we could help facilitate on your behalf to make sure those issues are being addressed appropriately. So anytime, especially when you have leaks and stuff like that, that's concerning to me because if you have a leak in a powered electrical junction box or something, that's a fire hazard. So that's all pretty serious stuff. So I would certainly make sure that my office is, if it's in the city of Columbia, make sure my office is aware of those situations so we can do an inspection and make sure units even safe to be occupied, because if it's not safe, we don't want you to stay in there. So certainly reach out to us on that, probably afterwards or something. If you want to give me an address or location, we'll certainly look into it.
issue, and no fighting.
Well, we were close with the fire department, so I would say whenever you told the location, it sounds like we probably need to do a joint inspection with the fire department and take a look and see what's going on there and make sure that the landlord's doing what it's supposed to be doing. Yeah, certainly let us know what the location is, we'll look into it.
In terms of your car being towed, I don't know what the circumstances of that was, but what is that? If you give me a call, you got me a number. I recognize Jamie Devine out there. He's with the commissioner on our school board. I want to do that very quickly, because every so often the school board has a forum just like this, and they invite the families or children in the district to come out and talk about housing issues. And some of the same things that they bring up, we're discussing here tonight. So I just wanted to thank you for that, Commissioner.
Thank you.
All right, that concludes our session for tonight. Let's give our panel a round of applause for our job that they did on tonight. We have about 15 minutes that you can walk around and speak with these individuals about any issues or concerns, and they have some free items. Again, on behalf of the City of Columbia and Richland County, we would like to thank you for coming out and getting all this great information they provided us tonight. Thank you.
Yeah, I gave you get approval for that. Get approval. You gotta get approval. Our headquarters is in Greenville.
I got one more question.
Yes, ma'am.
How you doing?
Fine.
You talked about the trial, jury trial taken away. And getting our bond support. It's a little problem. They have a big rule of certain type of bonds. Once you insurance, the jury filed with an insurance bond. That's what they do here in the situation.
We're housing our service.
As a right, and
We can't use that as an
what is your
excuse.
rent?
Right.
So the rent is your month. Right.
I'm looking out
Say you owe
and need
2,000 back.
service down.
Judge can also say if you 2,000 or 8,000 back rent. If you can't pay the bond,
More than three.
once they sell it.
We had a case like that. What happens is, we used to get some kind of
Only in a drug.
code says that the
Bench trial, it goes faster than
insurance company have to allow you
They
to
take
have
all kinds of evidence, whatever we want to see.
that can't be
Videos, photos, live testimony. But it's it's faster than the jury just made.
Ask me again.
I know that it's not making the rent.
Right.
But the jury